SwayamPrabha. Digital India. Educated India.
Hello friends, welcome to the class of Maritime Law. I am Dr. Ashutosh Acharya, Senior Assistant Professor from Law Center 2, Faculty of Law, University of Delhi. Well friends, we will continue from the last lecture wherein we were talking about shipping laws and regulations in India. And today we will discuss and talk about the part 3 of shipping laws and regulations in India, which will be inclusive of charter party contracts, bill of lading and carriage of goods by sea. Wherein if we talk about charter party contracts, we must know that there is a connection which is to be established between the buyer and the seller and the ship owner. And friends, it is the charter that establishes the connection between the buyer, the shipper and the ship owner. And how charter party contracts play its role, a significant role as far as chartering of a vessel is concerned. And when I say chartering of a vessel, it means to say, and I mean to say, that a vessel is chartered or is engaged for a particular purpose, and that purpose is to load the goods, unload the goods, and those goods are ultimately a contractual or is a result of a contractual relationship between a buyer and a seller in one part of the world to another part of the world or within the same country. So, we will look at the different types of charter party contracts. What is the role of charter? What are the rights and responsibilities of a charter? What different problems can arise as far as relationship between a charter and a shipper is concerned and a charter and a ship owner is concerned? What complexities or legal complexities can come into being as far as this whole relationship is concerned? What if a ship starts from one particular place and reaches to another particular place, and the ship owner has a claim against the charter, and ultimately the ship owner detains the cargo. The ship owner does not have any contractual relationship with the shipper, that is the seller, but has a contractual relationship with the charterer, where the ship is under the control of ship owner and not the charterer right now. What will happen to the rights and cargo or rights of the seller and buyer with respect to the cargo in such situations? We will discuss all of those pertinent issues that come into being through certain case laws as well, decided case laws. Further, we will also talk about COGSA, that is Carriage of Goods by Sea Act, which is basically a compliance of international norm or international law pertaining to carriage of goods by sea. What are the rules and regulations as far as carriage of goods by sea are concerned? So, this is the last part wherein we will talk about shipping laws and regulations in India, because in the first part we have already discussed the collision part, the passenger safety part, the pilgrimage part, and all of those things where the ship carries people from one place to another place has already been discussed. Obtaining certificates, safety certificates, etc. are concerned. In second part, we had already discussed about load line, anti-fouling system. In briefly, we also discussed limitation of liability and liability as well. Today also we will talk about, to an extent, how liability can be imposed as far as carriage of goods by sea is concerned. What are the faults that can come into being to impose liability, and then how liability comes into being. So, all these three parts of shipping laws and regulations in India gives us an holistic view of how shipping laws exist in India with respect to important aspects which may be safety, carriage, charter party, bill of lading, load line, etc. Now, in this lecture 12, let us start with the charter party contracts first. Now, what do we mean by charter party contracts? So, the term charter party stands for the contract between the owner of a vessel and the charter, which is the one that takes over the vessel for a certain amount of time or voyage. When there is an agreement or contract to carry some goods or provide a ship for carrying the same, a document called charter party contains the contract of affreightment. What do we mean by the word affreightment? It is a transport of goods in lieu of a freight. Freight means a money or cash or an amount that will be paid in lieu of transportation of goods from one place to another place through sea. By this document, the ship owner lets the ship for the purpose of carrying the cargo or undertakes to carry the full cargo on the ship. So, ship owner need not necessarily be the person who loads the goods and then carries the goods and delivers it to some other person. A ship owner can merely be a ship owner and allow a charterer, a kind of a middleman who functions as a facilitator in order to allow establishing contact between the seller and the buyer. So, charterer will charter the ship from the ship owner, will enter into contract with the ship owner. Once this ship is chartered, then the charterer can load the goods and deliver it to the place where it is supposed to be delivered. So, charterer is basically acting as a facilitator between the three parties, that is the ship owner, the shipper, that is, or the seller or the buyer. So, it is a very important role because three types of relationships are coming into being or with the three types of parties, and therefore, charter party contracts are necessary to be understood. Also, for the very basic reason that the charter party contracts exist in different forms, and we will discuss all of those forms, that in what all forms charter party contracts exist depending upon the nature of the charter party contracts. So, as defined in the Black's Laws dictionary, a charter party means a contract by which a ship or a principal part of it is led by the owner, especially to a merchant, for the convenience or for the conveyance of goods on a predetermined voyage to one or more places. A special contract between the ship owner and charters, especially for the carriage of goods, etc. The contract of affreightment may be either in the form of bill of lading or a charter party. A bill of lading is a pure and simple contract to carry the goods, whereas a charter party involves the complete hiring of the ship itself. So, in a bill of lading contract, the shipper hands over the goods to the charter party, and these goods of the bill of lading or the title of the goods is also somewhere down the line carried or possessed by the charterer. And this charterer, when delivers the goods to the buyer, also hands over the bill of lading, or you can say the title of the goods, to the buyer. In that case, the shipper is somewhere down the line free from the goods. The charterer has taken over the responsibility of the goods while it transfers the goods. Whereas in charter party contracts, the charterer is merely a carrier of the goods on behalf of the seller. Now, here the contract between the buyer and seller becomes also important, where in the goods are loaded upon the ship, the contract will identify that whether the liability of the goods is transferred to the buyer, or the liability of the goods is still in the hands of the seller. Where the seller wants to exercise his or her right to disposal, the title or the possession of the goods will not be deemed to have come into place in the interest or in favor of the buyer. That is, it will still remain under the control of the seller, because the seller is not sure, or seller is in doubt that whether the buyer will pay for the goods that has been chartered or not. In case the buyer fails to pay for the goods that has been chartered, the seller can always exercise the right to disposal, that is not to pass on the title of the goods upon the buyer. In that case, always the seller will be responsible as far as the goods are concerned. Therefore, in another scenario where the contract is of FOB contract, that is free on board, in such contracts the goods one loaded upon the ship or the vessel then or chartered, then the title of the goods you can say is transferred to the buyer. In that scenario, the buyer will be responsible for the goods if anything happens to the goods on voyage. So, I will read it again. A bill of lading is a pure and simple contract to carry the goods, whereas a charter party involves the complete hiring of the ship itself. In simple terms, if a ship is booked by a shipper for his exclusive use for a voyage or for certain period of time, that is called charter party. The importance of charter parties in international trade. Charter parties play a vital role in facilitating global trade, ensuring the efficient transportation of goods by sea. These agreements establish clear responsibilities and liabilities for both ship owners and charters, promoting smooth operations and minimizing disputes. Let us explore why charter parties are crucial in international trade. By identifying the role of charter party, what do they actually do? So, firstly, they facilitate global trade by providing vessel availability. Charter parties enable ship owners to make their vessels available for hire, allowing them to meet the demand for transporting goods across borders. This availability ensures that businesses can access reliable shipping services to move their products worldwide. Ensure efficient transportation of goods by sea. By defining the terms and conditions of carriage, charter parties help streamline the logistics process for ship owners. They specify loading and unloading procedures, delivery timelines, and any additional requirements for cargo handling. This clarity promotes efficiency and helps avoid delays and misunderstandings during transit, benefiting both ship owners and the overall shipping industry. So, basically a charter is the one who is considered to be an expert, who is considered to be a techno-friendly body that will ensure the timely loading, unloading, delivery and all of the procedural aspects that are responsible as far as transportation of goods from one place to another place is concerned. When will the voyage begin, when will the voyage end, depending on the weather conditions, depending upon the sailing of the ship, etc. So, considering all the variables and factors as far as sailing of vessel from one point to another point is concerned and loading aspects are concerned, the requirements of the flag states are concerned, certificates etc. are concerned, once all of which is available and which is the responsibility of the charter, it takes away all the headache or you can say all the burden away from the ship owner and also from the shipper in order to facilitate all of this international trade. So, unless and until there is availability of a charter, it will certainly become difficult in modern time, in today's time, in contemporary time to execute all of the international trade that we see. So, it is a whole large industry that is placed, which is known as shipping industry and is dependent on the shoulders of charters to a certain extent. Further, establish clear responsibilities and liabilities. Charter parties outline the obligations of both ship owners and charters, ensuring accountability throughout the voyage. They determine who is responsible for vessel maintenance, crew expenses, insurance coverage and compliance with maritime regulations. And when we say maritime regulations, we mean to say, let us say if we are talking about the rights of the crew members, then we will certainly have to look at Maritime Labour Convention, the Indian implementation of Maritime Labour Convention, then we will have to look at the Merchant Shipping Act. If it is a Indian flag ship, then in that particular scenario, whether the ship complies with all the Indian regulations, whether it has all the certificates. Now, the contract between the charter party and the ship owner will identify who will bear what responsibility, and therefore, this contract becomes essential as it clarifies the essential responsibilities and interests of both the parties, which will be useful in identifying future liability if it comes into being. Clearly defined responsibilities minimize uncertainties and protect all parties involved. Now, as you can see, the charter's role is in between. So, it is the ship owner who issues charter party bill of lading in favor of the charter. So, here we have the ship owner and we have the charter, where charter party contract will be entered into between the ship owner and the charter, which will be known as charter party bill of lading. And then if there is a contract of carriage between the charter and the seller, or also known as the shipper, then that particular contract will be known as contract of carriage, because charter is merely carrying his goods to be delivered to the buyer or the purchaser. So, charter actually performs a task of the facilitator between the ship owner, the seller as well as the buyer. Further, we see that charter is a person who has taken the vessel on hire, thus becoming the commercial operator of the vessel. Now, when the shipper loads his goods, his bill of lading is issued by the charterer. So, when the relationship is between the charterer and the ship owner, it is the ship owner who issues the charter party bill of lading, and when the relationship is between the charter and the shipper, it is the charter party, it is the shipper who issues the bill of lading to the charter. Now, when the shipper loads his goods, his bill of lading is issued by the charter. So, once the shipper loads the goods upon the ship, the charter will issue the bill of lading to the shipper as a carrier and not the ship owner. These are known as charter party bill of ladings. The contract between the shipper and the charterer is known as contract of carriage, and the contract between the charterer and the ship owner is called charter party, as we have depicted already into the figure. It is therefore evident that no direct contract exists between the shipper and the ship owner under charter party bill of lading. So, as we have already seen in the previous, so no direct contract exists between the ship owner and the shipper. The contract is between the ship owner and the charterer. So, though signed by the master of the vessel, who is a representative of the owners, in reality the charter party bill of lading is issued by the ship captain on behalf of the charterer of the vessel, and effectively it is the charterer who issues the bill of lading to the shipper for the goods being shipped on board the vessel he has chartered. For the charterer, it is merely a receipt for the goods. I repeat that for the charterer, it is merely a receipt for the goods from the shipper or from the seller shipped, as all the terms and conditions are mentioned already in the charter party. It is important to understand that while a marine bill of lading is issued by the ship owner or his agents, as charter party bill of lading is issued by a charter or his agents. Now, look at the previous paragraphs, as it says, for the charter it is merely a receipt for the goods shipped, as all the terms and conditions are mentioned already in the charter party. We need to understand that when bill of lading is handed over by the shipper to the charterer, the bill of lading will contain necessary requirements and descriptions of the goods that are to be shipped, because every good or different types of good will have different requirements. So, the charter will have to take care of the requirement of the good. Further, as against a normal marine bill of lading, where the bankers are more comfortable in extending credit, they are very apprehensive about accepting charter party bill of lading. Now, this marine bill of lading will show the description of the good and will also act as the title of the goods, or it is considered to be receipt of the goods. Now, if a buyer wants to borrow some money from the bank so that the goods can be purchased or support from the bank would require some amount of collateral or something which acts as a collateral. The bill of lading, once delivered to the bank, will allow the process of payment to be made to the seller. So, bill of lading acts as a document which will also help the purchaser to purchase the goods where there is an insufficiency of funds to purchase the goods. Therefore, to make matters simple, when we transport goods by truck and the goods get damaged, we hold the carrier liable. In charter party bill of lading, it is the charter who is the carrier for shipper, even though he has loaded his goods on a ship. I repeat that in charter party bill of lading, it is the charter who is the carrier for shipper, even though he has loaded his goods on a ship belonging to the ship owner. At times, this could present difficulties to the shipper. For instance, if charterer fails to pay the charter hire to the ship owner, the ship owner can withhold the cargo for non-payment. In such a situation, it is the shipper or the owner of the cargo who suffers. But frustratingly, the shipper or the owner of the goods cannot move against the ship owner, as he has no contractual relationships with him. The situation becomes even more complicated if there is sub-charter also involved, as some charter parties do permit the charter to further sub-charter the vessel. The Uniform Customs and Practice for Documentary Credits UCP, drafted by ICC International Chamber of Commerce, is a set of rules utilized by bankers and commercial parties of trade finance. A marine bill of lading is covered under Article 20 of UCP, Uniform Customs and Practices for Documentary Credits 600, while Article 22 covers charter party bill of lading. As per Article 22, if a letter of credit calls for a charter party bill of lading or mentions that charter party bill of ladings are acceptable, then presenting a charter party bill of lading would comply with this condition. A charter party bill of lading should contain an indication that it is subject to a charter party and can be signed by the master, the owner or the charterer or their agent on their behalf, as against the carrier or the master or their agent in the case of marine bill of lading. Under charter party bill of ladings, problems can also arise where the ship owner has first chartered the vessel to a charterer under the charter party, and the charterer in turn contracts with the shipper under a contract of carriage on terms different from the charter party. And this also raises a problem wherein the relationship, as we know, does not exist between the ship owner and the shipper. So, if there are two different terms in two different contracts, and if problem comes into being where there is a tussle between, or where there is question of preference to be given between these two types of contracts, which will prevail, and if there is extra liability or extra responsibility in the charter party bill of lading contract between the ship owner and the charterer as compared to the simple marine bill of lading between the shipper and the charterer, then what will happen in such situation where lesser responsibilities are in place in the second contract? Then what will happen in such situation? Such complexities do come into being. So, therefore, two crucial questions which must be answered in such scenarios, or in this case, are where there is a conflict between the terms of the bill of lading and the terms of the charter party under which it was issued, which terms would be binding on the shipper, the charter party terms or bill of lading terms. And second question is, who is the courier where goods are carried on a chartered ship? So, in Leduc versus Ward 1888, Queen's Bench Division Court ruled that when the bill of lading is issued as a follow up of the charter party between the charter and the owner, then bill of lading is merely a receipt of goods, as all the main terms of the carriage are already in the earlier contract, that is with the charter party bill of lading. Now, consider a FOB contract, free on board. As I have already told you, a free on board contract would be wherein the responsibilities or the liability of the goods or the title of the goods gets transferred immediately after loading of the goods. The title or the transfer of the title of the goods or responsibility does not have to wait for the unloading of the goods or receiving of the goods by the buyer. Moment it is loaded, the responsibility gets shifted or transferred from the seller to the buyer. So, an FOB, now consider an FOB contract where the charter is also the consignee, as in the case of President of India versus Metcalfe 1969. The charter was caught by a term, an arbitration clause of the charter party, even though there was no such clause in the bill endorsed to him by the shipper. Thus, where the charter takes the bill directly from the shipper, his seller, it is clear that the endorsement of the bill to the charter is very much an incident of the contract of sale and is in no way intended by any of the parties to alter the contractual agreements between the shipowner and the charterer contained in the charter party, and hence any variations in terms between the charter party and the bill of lading can give rise to serious disputes, where largely the charter party bill of lading would be given preference to over the other contract. Now, there are different kinds of charter which we will now be discussing dependent upon the utility and usage of the ship, and based upon that utility and usage of the ship, the charter and the ship owner will enter into contractual terms. The charter parties can be broadly classified into two kinds, namely voyage charter parties and time charter parties. The voyage charter party contract would be based on the voyage from point A to point B, and time charter party contract will be for a particular period of time. So, hiring of vessel for a particular voyage and hiring of vessel for a particular period of time will be the identification factor as far as voyage charter party contract is concerned and time charter party contract is concerned. Therefore, time charter parties are also known as charter parties by demise, because the ship is leased out to the charterer for the time being. And when I say it is based, a particular kind of time charter party contract would be demise charter party contract. It means it is a kind of time charter party contract. However, in that particular time, the ship is hired for all purposes. That means the crew member also has to be placed by the charterer and it will not be placed by the ship owner. So, an extended version of time charter party contract can be called as demise charter party contract, because the ship is leased out to the charterer for the time being. Whether a charter party is voyage charter party or time charter party or time charter party would depend on the intention of the parties that will be shown in their contract. There is yet another kind of charter party known as port, berth or dock charter party contract, which we will discuss. Now, first starting with the voyage charter party contract. According to Black's Law Dictionary, a voyage charter is a charter under which the ship owner provides a ship and crew and places them at the disposal of the charterer for the carriage of cargo to a designated port. The voyage charterer may lease the entire vessel for a voyage or a series of voyages, or may lease only a part of the vessel by a space charter party. Under a voyage charter, the vessel is let out to the charterer for a specific voyage. The ship owner will be paid freight which will cover its costs, including fuel and crew, as well as its profit. Legally, freight is a special type of payment, as the usual rule of set off will not apply to it. A set time, lay time will also be provided for the loading and discharging operations. If these operations exceed the permitted lay time, the ship owner will be compensated by demurrage at the rate set down in the charter. Demurrage is basically a time period which got extended, or which wherein if the time is provided, or wherein the ship was supposed to reach a particular place in a particular point of time, but had to wait for certain specific reason, then the certain amount is calculated because of that particular delay in reaching to a particular port or harbor or a particular point. So, that amount will also be calculated. For its part, the ship owner owes the charter the duty of proceeding with reasonable dispatch on the charter party voyage or voyages in the case of a consecutive voyage charter. A voyage charter differs from time charter in many respects, but primarily in that it is a contract to carry specific goods on a defined voyage or voyages. The remuneration of the ship owner being a freight calculated on the basis of the quantity of cargo loaded or carried, or sometimes a lump sum freight. A voyage charter party usually carries a cancellation clause that gives the charterer the right to cancel the charter if the ship is not as at his disposal at the port of loading at the specified time. The charterer would have to fix a cancellation date before exercising this particular right. Another type of charter party contract is time charter party contract. A time charter party is also known as charter party by demise. Morgan defines time charter as a contract for the hire of a ship or charter party for a specified period of time. The charter pays for the bunker fuel, fresh water, port charges, etc. in addition to the charter hire. According to Black's Law Dictionary, charter for a specified period rather than for a specific task or voyage, a charter under which the ship owner continues to manage and control the vessel, but charter designates the ports of call and the cargo carried. Each party bears the expenses related to its functions and for any damage it causes, also termed as catch time charter. A charter by demise operates as a lease of the ship itself, to which the services of the master and the crew may or may not be superadded. The charter becomes for the time being the owner of the vessel, the master and crew become his servants, and through them the possession of the ship is in him. So, for a particular period of time, the charter takes the responsibility of the ship owner and controls the crew and the master of that particular ship, and within that period of time ship belongs to him, and he can use within the time the places where the voyages are supposed to take place. Under a charter not by demise, the ship owner agrees with the chartered to render services by his master and crew to carry the goods that are put on board his ship by or on behalf of the charterer. In this case, it was held that the ownership and also the possession of the ship remained with the original owner through the master and crew, though the charterer has the temporary right to have his goods loaded and conveyed in the vessel. So, basically the charterer becomes a temporary owner for that period of time he has hired the vessel. Bareboat charters, another kind of charter party contract. Bareboat charters involve ship chartering by leasing a vessel without crew or provisions. So, generally we have seen that crew members are provided. In certain instance of time charter party, the crew and the master would be falling under the control of the charterer. However, another situation wherein the crew and the master is appointed by the charterer and not by the ship owner, then that particular type of contractual relationship or that particular type of arrangement between the ship owner and the charterer would be known as bareboat charter party contract. And bareboat charterer would lease the vessel and appoint the crew and take care of other provisions as well. In this type of arrangement, the charterer assumes complete responsibility for operating and maintaining the ship during the agreed charter party duration. the ship owner transfers possession and control to the charterer, who becomes the carrier responsible for all aspects of navigation, crewing and provisioning. These main types of charter parties include time charters, voyage charters and bareboat charters, offer different options depending on specific needs and requirements of the charter party, carrier, ship owner or the ship owner. Time charters provide flexibility and extended use. Voyage charters focus on individual trips, while bareboat charters grant full control of to the lessee. By understanding these various types, individuals and businesses can choose which option best suits their particular circumstances. Another additional charter party types of contracts would be port, berth or dock charter party contracts. A charter party that simply states the port at which the ship shall be made available is called port charter party, where the ship is to be made available at the specified loading spot in a port or dock. It is called berth or dock charter party. In such a case, the obligation of the charterer is to bring the ship at the specified berth or dock. If that place is not in position to receive the ship due to some congestion or some other cause, the waiting period would go to the ship owner's account. In the case of a port charter party, it is enough for the ship owner to bring the ship to the area of the port where ships usually wait for berth and from where it can be put at charter. Such area is designated as the commercial area of the port. There have been difficulties in identifying the commercial areas of a port, but the House of Lords held that the emphasis has been not on distance from the loading place but upon the fact that the ship should be at the disposal of the charterer. Charter party agreements. Charter party agreements are legally binding documents that are negotiated between ship owners and charterers. These agreements specify important terms such as freight rates, lay time, demurrage and more. So, we have already discussed this particular aspect, that it is a contract. The particular specifications of the charter party contracts we will look at. So, largely it will include freight rates, lay time, demurrage and certain related aspects. Specifically what all terms and conditions, what all clauses are mentioned in charter party contracts we will look at now. So, the charter party agreements are contracts that outline the terms and conditions of the chartering arrangements for container ships. They are typically negotiated between the ship owner who owns the vessel and the charterer who will be using the container ship for a specific period or voyage. Charter party agreements include various provisions that define important aspects for ship owners. This includes details about freight rates, the cost of hiring the vessel, lay time, the allowed time for loading and unloading cargo. Sometimes the loading of the cargo takes more than the specified time, sometimes the unloading of the cargo takes more time than the specified time. Who will bear the responsibility, all of which is mentioned under the charter party contract. The liabilities, the responsibilities are mentioned, identified and mentioned into the contract. In case of dispute, what will be the dispute settlement clause, if it is arbitration or any other mode of dispute settlement is also mentioned in the charter party contract. Demurrage, additional fees if there is a delay in cargo operations and other relevant terms. Legally binding documents. Once both ship owners agree to the terms outlined in a charter party agreement, it becomes a legally binding document. This means that both ship owners are obligated to fulfill their respective responsibilities as stated in the agreement. Charter party agreements play a crucial role in the shipping industry by providing clarity and protection for all parties involved. They ensure that both ship owners and charterers understand their rights and obligations throughout the duration of the charter. Whether it is a slot charter, a partial space booking or a demise charter, complete transfer of vessel control. These agreements establish clear guidelines for smooth operations. Now, what are the usual clauses that a charter party agreement includes? We will look at those general usually used clauses. So, it is open to the parties to include in a charter party or a contract of affreightment any lawful terms, but many such terms have now become more or less stereotyped and are known as usual clauses of a charter party. The use of these laws depends upon its relative importance. Of some of such terms are Ready to load. Charter party usually contains a statement as to the position of the ship. In certain circumstances, such a statement may become the term of the contract. Any breach of this term entitles the charter to repudiate the contract. Now, for example, if you look at Benson versus Taylor Sons and Company, a charter party dated March 29th described the ship as now sailed or about to sail to the United Kingdom. That is, it will sail around 29th of March and it is ready to be loaded, and that the ship, after discharging homeward cargo, shall proceed to load. But in fact, she sailed to the UK on April 23rd, approximately a month later on the specified date. The parties then entered into correspondence. The ship arrived and the charters refused to load. The court went on to hold that the main substance of the contract was the description of the ship as now sailed or about to sail. The court then took a look into the subject and went on to hold that the above said description is not a mere warranty, and so the defendants had the right to repudiate the contract, since the date or the time acted as a condition of the contract, but their correspondence amounted to waiver such a right to repudiate, and they were liable for their freight, subject to their right to recover such damages as they could prove that they had sustained by reason of the breach of the condition. The court then looked into the clause that the ship is expected ready to load at a given date, but the court went on to hold that this does not mean that the ship must not be in such a position. It only means that there must be an honest belief founded on reasonable grounds that the ship will be loaded at that date, but the ship at that date was not ready to be loaded until a long time afterwards, but a representation was made without any reasonable grounds for making it, and this was a breach of condition, and that was that it will be ready to be loaded on 29th, but was not ready to be loaded till 23rd of April. So, therefore, there was a substantial delay. Fit for voyage is another clause that we find available or find mentioned in the charter party contracts. Charter parties usually provide that the ship shall be tight, staunch and strong and every way fitted for the voyage. The Court of Appeal has admitted in Hong Kong Shipping Company Limited versus Kawasaki Kisen Kaisha Limited that it is difficult to distinguish whether such statements are conditions or mere warranty. In this case, a charter party provided that the ship was in every way fitted for ordinary cargo services. The experience of the voyage was different, as the ship kept breaking down time to time. Actually, this was due to incompetence and inadequacy of the engine room staff, but it was held that the statement as to the seaworthiness of the ship was not a condition, and the charters were restrained from repudiating the contract, and it was only treated as a warranty, wherein some amount of compensation could be laid down. Now, Lord Justice Diplock in Benson versus Taylor Sons and Company has said that stipulation as to the seaworthiness of a ship is of complex nature. Now, when we say about charter party contracts, what are the stipulations are to be looked from the nature of the contract and from the construction of the contract, and from that particular aspect or from the contract stipulation we will identify that whether a particular aspect is a warranty or a condition. If it is a warranty, then repudiation of contract will not come into being. Perhaps it can be a breach of warranty and compensation could be placed in. But if it is breach of condition, certainly the purchaser have the right to repudiate the whole contract itself. So, it has said in this particular case, Lord Diplock has said that a stipulation as to the seaworthiness of a ship is of complex nature. He said that the ship owners undertaking to tender a seaworthy ship. So, if a ship is seaworthy, that means the charter or the ship owner has performed their duty as far as ensuring that the ship is seaworthy. Now, if anything goes beyond that particular responsibility, then it is not or it should not be the fault of the charter or the ship owner. So, therefore, when we talk about the perils of the sea, seaworthiness of the ship is one aspect. Apart from seaworthiness of the ship or unseaworthiness of the ship, there are other aspects also that must be taken into account, and therefore it says, he said that the ship owner's undertaking to tender a seaworthy ship has a result for numerous decisions as to what can amount to unseaworthiness become one of the most complex of contractual undertakings. It embraces obligations with respect to every part of the hull and machinery, stores and equipment and the crew itself. It can be broken by the presence of trivial defects easily and rapidly remediable, as well as by defects which must inevitably result in total loss of the vessel. Full and complete cargo is another clause that we generally find. Full and complete cargo means that the charterer undertakes to supply the agreed cargo lest the ship owner may suffer loss of freight. In Heathfield Company Limited versus Rodenacher, the charter refused to load more than 2,673 tons, but the full and complete cargo would have been 2,950 tons. The court held that the charter ought to have loaded full complete cargo and freight was payable accordingly. In another case, the charter agreed to load cargo not less than 6,500 tons and not exceeding 7,000 tons. The court laid down that not less than 6,500 tons was a warranty given by the ship owner to the charter that much quantity can be loaded, and the weight not exceeding 7,000 tons was a binding condition, preventing the ship owner from asking more quantity than 7,000 tons. In this case, the ship owner asked for more than 7,000 tons and the charter was forced to bring the quantity. He brought that under duress and protest. Now, the ship owner claimed extra freight for that extra quantity, but the ship owner was not allowed to recover the extra freight for that extra quantity. The ship owner is also bound to provide sufficient space on board for full and complete cargo. In Darling versus Regburn, the ship owner loaded large amount of bunker coal than what was required for that voyage, and this reduced the space for full and complete cargo, which resulted in reducing the cargo. The ship owner was held liable for the expenses. The clause giving protection to failure to load the cargo will apply only if the loading itself is prevented and not where the party is unable to bring such goods to the port. Loading can be prevented by strikes, frost or other unavoidable accidents. In a decided case, the goods could not be brought to docks due to frost. The House of Lords held the charter responsible for the delay in loading, as the frost has not prevented the loading but the bringing of the goods to the docks. Now, apart from these general clauses where we see the imposition of liabilities can come into being and what have been the decisions of the court, especially the House of Lords or Queen's Bench division, or in a particular Indian case, we have seen that how courts face these complex issues in order to identify the liabilities, whether there is breach of condition or breach of warranty. In addition to these clauses, we have certain other peculiar clauses also, which are king's enemies and restraints of princes. The charter parties usually provide that the ship owner would not be liable in certain events. For example, there would be no liability on events arising out of act of God or because of national enemies. Acting as an exceptional scenario or giving a saving clause, we generally know that in tortious matters also, where liability is to be imposed in certain tortious matters. Similarly, here also in charter party contracts for act of God or for any other particular type of event which are out of the control of the parties, in such events the exemption of liability will come into being. So, for example, there would be no liability on events arising out of act of God or because of national enemies. Such perils or dangers are known as accepted perils. The words king's enemies mean the enemies of the country or the sovereign of the person who made the bill of lading. All restraints or interruptions made by any lawful authority are considered as restraints of princes. The dangers from the sea pirates are not included in this category. In a decided case, a ship owner was justified in the non-performance of a contract which involved the voyage through Turkey. It was obvious that the ship would be seized because of war between Turkey and Greece. In this case, the war has already been declared, but if there was only a mere speculation that there would be a war, the charterer cannot be justified if he repudiates the contract. A voyage which involved the risk of the ship being sunk by German submarines was held to be one that involves the risk of seizure or capture. If the intervention of the restraint is due to the negligence of the ship owner, he cannot avail the exception of this clause. Perils of the sea. Charter parties also contain an exception in favor of the dangers of the sea, that is, If the goods are lost or damaged on account of a peril of the sea, the ship owner would not be held liable. The term peril of the sea does not cover every accident or causality which may occur to the goods in the ship. It must be a peril of the sea. The natural action of winds and waves is not considered as perils of the sea. There must be some causality, some which could not be foreseen as one of the incidents of the adventure. For example, the cargo in a ship was damaged due to the collision of that ship with another ship, which according to the House of Lords was a peril of the sea. In Hamilton, Fraser and Company versus Pandolf and Company, rice was shipped under a charter party which contained the exception for the dangers and accidents of the seas. During the voyage, some rats gnawed a hole in a pipe on board the ship, which resulted in the seepage of sea water and damaged the rice. Here the rice was damaged without the neglect of the ship owner or the crew. The court held that damage was within the exception of perils of sea and the ship owners were not held responsible for the loss. In this case, if rats directly damaged the rice, then it would have amounted to the neglect of the crew and they won't be getting this exception because there is no direct relationship between the sea and this accident. But here the sea water damaged the rice and this was not a foreseeable accident. In also we see that in a lot of other tortious matters also we have seen that foreseeability is an important factor as far as negligent act by the perpetrator is concerned. So, wherever negligent act is in question with respect to the ship, the charterer or the ship owner, then in case of imposition of liability we see foreseeability also acts as a factor. So, if it is unforeseeable event, then liability cannot be imposed upon the responsible person. Similarly, a damage caused by the collision of two vessels due to the negligence of either of the vessels will not be a peril of the sea. Charter parties and bill of lading. A bill of lading issued under the charter party terms serves as a crucial document for ship owners in the shipping industry. It provides evidence of cargo receipt and condition, making it essential for transferability and financing. Under voyage charters or bareboat charters, a bill of lading is often issued to acknowledge the receipt of specific cargo by the ship owner or charterer. This document is essential for ship owners and the charterers in the shipping industry as it serves as proof that the cargo has been loaded onto the ship and is in good condition. It is particularly important for both bareboat charter and voyage charter party agreements during the specified charter period. Charter parties facilitate the agreement between the ship owner and the charterer, outlining their respective rights and responsibilities. The bill of lading acts as a contract between the carrier and the shipper, ensuring that both parties fulfill their obligations. For freight forwarders, having a bill of lading issued under charter party terms allows them to confidently arrange transportation for their client's cargo with the ship owner's assurance. And therefore, the bill of lading also enables financing options for shippers who may need to use it as a collateral or provide proof of ownership for obtaining loans during a bareboat charter, slot charter or voyage charter party within the charter period. In addition to its importance in commercial transactions, bills of lading issued under charter parties serve as critical documents for ship owners' insurance claims related to damaged or lost cargo. So, if any peril of the ship happens which are mentioned in the insurance agreement, marine insurance agreement, and if any damage happens to those goods, it is the bill of lading that will allow the claim to proceed as far as marine insurance is concerned. So, for that purpose also bill of lading is quite important. Charter parties and bill of lading are integral components within the shipping industry. They ensure smooth operations, protect stakeholders' interests and provide necessary documentation for various purposes. Now, ship speed and fuel consumption in time charter to make an informed decision. Ship speed plays a crucial role in determining fuel consumption within time charter agreements. Again, an important clause that can be mentioned in the charter party agreements. Now, the problem that can come into being with respect to ship speed and fuel consumption is that if the ship is running slow, then fuel consumption is lesser. The ship is running at a high speed, fuel consumption is more. But another problem that comes into being is that if ship is running slow, it might get delayed in reaching to its destination, and this will further delay the transportation of goods from one place to another place. So, there has to be a balance that has to be drawn between the ship speed and the delivery of the goods. As far as efficiency part is also concerned, we must take care of that particular aspect as well. So, ship speed plays a crucial role in determining fuel consumption within time charter agreements. The rate at which a vessel travels directly impacts the amount of fuel it consumes during its journey. Here are some key points to consider. Slow steaming, slowing down the ship's speed, can significantly reduce fuel costs. By adopting this practice, charter parties can achieve substantial savings. However, it is important to note that slow steaming also extends the duration of the voyage. Cost versus time. When deciding on a ship speed, charter parties must strike a balance between the cost reduction and voyage duration. While slower speeds may result in lower fuel consumption, they can lead to longer transit times, affecting overall efficiency and profitability. Fuel efficiency considerations. In time charter agreements, fuel efficiency is a critical factor that influences financial outcomes. Parties involved must carefully evaluate the impact of ship speed on fuel consumption to ensure optimal profitability. By considering these factors, charter parties can make informed decisions regarding ship speed and its effect on fuel consumption within time charter agreements. Achieving the right balance between cost reduction and voyage duration is essential for maximizing profitability while maintaining operational efficiency. Understanding lay time and total lay time. Lay time, a crucial aspect of charter parties for ship owners, refers to time allowed for loading, unloading cargo. It determines the financial implications for both ship owners and other parties involved. Exceeding the lay time incurs demurrage charges, resulting in additional costs of ship owners. Key points that must be taken into account with respect to lay time and total lay time would be: lay time is the agreed upon period during which the charter has the right to load or unload cargo. It is typically expressed in days, hours, or even minutes. Demurrage, we have already discussed. Financial implication would be: understanding lay time is essential because it directly impacts both parties' financial interests. Further, we have safe port requirements in voyage and time charter parties, wherein voyage charters require the charters to transport cargo from one port to another ship by ship. In these agreements, it is crucial for the charters to ensure that the chosen port for cargo operations meets certain safety requirements. Similarly, time charters impose an obligation on the charter to nominate safe ports throughout the duration of the agreement. Other key points are with respect to voyage charters, time charters, and we also have Carriage of Goods through Sea Act 1925, which deals and takes care of the rights and responsibilities of the different parties involved in the carriage of goods through sea route. And therefore, with this, considering all the necessary factors and variables as far as carriage of goods through sea concerned, I conclude this particular lecture, wherein we have already discussed about the charter, shipper, buyer and the ship owner and their relationship amongst each other and different types of charter party contracts, etc. With this, I conclude and end this particular lecture. I thank you for your patient listening. Namaskar.